that's proof that this was a leak from the insider. So there's no secret about the fact that metadata never was, and Smith, any secret about the fact that metadata can reveal content.
And the point about the power of the technology now that allows analysis leads me back to the point that I wanted to make in response to Judge Lynch a moment ago, which is it's important not to lose sight of all of the other protections that are built around the acquisition and retention and use of the data under this program, given its bulk, the bulk nature of the production to the government, and in light of the technology. And I think that's critical to understand, that in addition to being only non-content information about the telephone calls, the data can only be queried for counterterrorism purposes, and then only if there's a reasonable articulable suspicion that the selection term, number or whatever, is connected, associated with a specified foreign terrorist organization.
None of those safeguards are built into the legislation.
The legislation, Your Honor.
The legislation is totally silent as to any of that.
I don't think that's right, Your Honor. So in 1861 subsection G, I believe it is, requires minimization procedures because I think the text of the statute reflects it was understood that this tool would be used to obtain data that would relate to a number of U.S. persons. And so the statute requires that the FISC or that the government propose and that an element of the program be robust minimization procedures. They've been spelled out then in detail in the orders of the FISC, but that there be protections around the use and dissemination of the data was reflected in the statute.
But now that we've got some experience with minimization procedures, it presumably would be possible to spell out something in legislation if this program were going to be authorized by Congress explicitly that said what made sense and what didn't make sense. I mean, after all, this just says the Attorney General has to specify. And so far the record is basically FISC signed off on what the Attorney General for. And when it got made more restrictive, that was because the Attorney General asked for it to be made more restrictive. And that's not a criticism of the FISC court because they're operating essentially in an ex parte context. Nobody's there saying, here's what would be better minimization procedures, or we think this is what the Constitution requires. The government goes in and says, here's a list of things we think you should tell us to do. And the court says, okay, you can. That's what you should. Those restrictions are approved, right? I mean, my concern about all of this is that if it's fine to say we've got this program and this is we never misuse this data. We only use it for these purposes, and we have rules to have that happen. That's not the same thing as the government not having that information sitting there, where I don't know what Mr. Snowden could have done. Maybe instead of leaking the order, he could have leaked the database to somebody. We don't know what happens when some inhabitant of the White House, this one or another one, has a plumber's unit and decides to let them have access to the database. These are realistic concerns about letting the government have this massive body of data without anything but even of course, look, anyone, I'm sure part of your answer has to be, and it makes sense, whoever makes the rules, they could be abused. If we told the government it can't do this, it has the technological capacity, and if we're imagining a government that breaks all the rules, they could get it anyway somehow. They could tap all our phones and we'd never know it, and if they're bad guys, these are all paper restrictions. But there are levels of restriction, and it's one thing to have Congress adopt a program and say this is what it is, and we've considered what needs to be done to give protections, and one that says, well, they can get what's relevant, but they should be careful how they use it. And then we infer from that this massive program.
So I think, Your Honor, I think the record on the enactment of Section 215 and its extensions respectfully goes beyond the last version that you just articulated. But I do think that the point about security area. The political branches being charged with, within a range, drawing the lines about what steps are appropriate to accomplish national security needs, something that the Supreme Court has articulated in the Fourth Amendment context, for example, in the Keith decision, urged that Congress draw some of these lines, almost, I'm not sure that this is the phrase that was used, but because some of these questions are susceptible, in effect, to legislative fact-finding about what is appropriate, what trade-offs are appropriate to meet the needs of national security. Similarly, in the McQuaid and Cassidy cases, this court, in evaluating types of anti-terrorism or counterterrorism activities in connection with the subways and ferries, noted that that the court should be reluctant to wrest away from the political branches the choices about how these judgments should be made and where the balance
should be very cautious about making a constitutional determination.
Right. And which is why I think, Your Honor, should evaluate the program that we have. There's obviously a desire to ask questions about what might arise in other contexts, but given that the Supreme Court has made clear that the reasonableness examination is a totality of the circumstances type question, and you do have Smith, and you do have the same type of information that was at Smith, if you're reaching the constitutional issues, we urge a focus on the program,
well,
which is lawful.
You agree we have to reach the constitutional issues?
Yes. I was referring to your preclusion point, which respectfully I think is a function of the regime that Congress established. And the Supreme Court has also recognized that where that is the case, where Congress has not provided APA cause of action, the consequence may be the examination of a constitutional, not a statutory claim. That was the issue in Webster versus Doe, and that was the result, that the court reached or said that the constitutional claim could be reached, not the statutory claim, because there was not an APA cause of action available.
It seems to me quite simple that the only way we can achieve constitutional avoidance in this case is by ruling against you on something statutory. Otherwise, we're forced to get there anyhow.
Right, and again, our position is that Congress...
You prefer we not rule against them.
I prefer that you not rule against us, that's certainly true, but that here, Congress has not provided jurisdiction for the court to reach the statutory claims. Then there's not an APA waiver of sovereign immunity, and so therefore we are left with the constitutional argument. There we think that you do it at the level of Smith versus Maryland, which we think remains binding precedent, and answers the question of whether it's a Fourth Amendment search to get the records from the telephone companies in this context, or if you go to the special needs inquiry and the reasonableness approach, if you look at the program as a whole, not just the initial collection, but the fact that the FISC has authorized that collection only upon the imposition of robust controls over when the data may be queried, what may be done with the results of the queries, very elaborately set out in the primary orders, and with reporting back to the FISC. This is not respectfully just and I think this is reflected in the court's opinions, which have now been declassified, not just the court accepting whatever the government offered, but making determinations according to its own statements that with these procedures, the program strikes an appropriate balance with providing the capability that is
in this order that imposes more restrictions than the government sought at the time?
I don't know the answer to that question. My point was that if you look at several of the recent opinions, which I had occasion to read, they're specifying.
I've never suggested there being some kind of rubber stamp. I'm just saying that the procedures there are a little different than the procedures that would be in place in a district court, or for that matter in Congress, in terms of having a robust consideration, not just from what the government says is a good idea to minimize and whatever the judge can bring to bear in his or her own experience, but to a real debate.
Right. So what I think what I can say is that although these particular orders are not in the joint appendix here, they Among the declassified materials from the FISC are opinions reflecting reactions to compliance issues that were identified and steps that the FISC took in response, which, as I recall, included orders that were not simply things that were proposed by the government, but that is a general recollection on that front.
I think you seem to rely in part, and properly so, on material that has in the last year and a half or so been declassified and therefore should serve to assure us that there is not a special needs problem or Fourth Amendment problem. It's odd. What else? That's what you've let us know. What else haven't you let us know? I mean, you were pushed to that for I say this with more than all due respect, with all respect. I'm not saying that's a bad thing, but all of this stuff that we now know, and we don't know, all of this stuff we now know is as part of a political reaction to the understanding that this program was in effect, isn't that so? I mean, aren't you arguing a good deal from material that was made, that was classified until June ago, and was made public as a reaction to that public action?
I mean, certainly that is true, that the information public in the public realm that had not been public before. But this program, and I think this is the critical aspect of the congressional design, was subject to Article 3 review from the beginning by operation of the FISC, which was a body that Congress set up specifically to accomplish that. Just as the intelligence committees act as the channel for oversight of the executive branch from the congressional side, where you're by necessity dealing with classified information.
It's entirely useless. I can't say this, but the whole system surely give one a much warmer feeling inside if it was not all ex parte, but there was some representative of the other side, even if that some representative of the other side was a pro bono amicus, or not pro bono. Pam, get Fitzgerald out from Chicago and have him argue the other side of these. And I for one, would find what you say, I'm not talking law now, that's why it's out of school, but I find this a lot more reassuring if it was subject to an adversary process, and that's not.
And as Your Honor may be aware, among the proposals that are currently pending for change to the program would include provisions that allow for, and more than one option on the table, the kind of approach that you're talking about. But in
that case, I vote for it.
But in fact, I think if you look at the reasonableness inquiry, for example, I think and balance the factors that the Supreme Court and this court have said should be balanced. On the one hand, there certainly is an overriding importance in preventing future terrorist attacks. Here, the intrusion, if any, subject to the Smith argument on the privacy of individuals is carefully cabined to allow the examination of the data, to allow the identification of connections only on finding of reasonable articulable suspicion and the other procedures that are in place. So the statutory and FISC-imposed safeguards limit the use, retention, and dissemination of the records that are collected. There's also an oversight system by the FISC and by Congress, as well as other entities in the executive branch. All of this, we submit, should lead the court, if evaluating the Fourth Amendment
So you call your cousin at the phone company.